Another very useful judgment of High Court related to input tax credit. There is a situation where the taxpayer purchased goods from a supplier. The registration of supplier was valid at the time of purchase. The payments related to purchase were made from bank. The supplier filed his return for that period. He filed his GSTR1 return, GSTR3B return, and that transaction is reflecting in GSTR2A or 2B of the buyer. All the conditions related to Section 16 was satisfied by the buyer and he claimed input tax credit. Now suddenly after some time, the buyer receives a demand notice from department stating that the supplier from whom the purchase was made is a non-existent supplier. As per an investigation report, the place of business of supplier was verified and he was found non-existent at that place. Therefore, this transaction is bogus and input tax credit is not allowed. The demand is made in the Section 74 alleging fraud. Taxpayer filed appeal before the first appellate authority where the demand was again confirmed. Now the taxpayer filed writ petition before Allahabad High Court. This has happened in two different cases. One is Khurja Scrap Trading Company and one is in the case of Solvi Enterprise. In both the cases, the taxpayer took plea that demand is made under Section 74 without giving any material evidence based on which the demand is made on me. I have satisfied all the conditions related to Section 16 and therefore this demand cannot be made on me. Plus, he has also relied on instruction number 5/2023 issued by CBIC, where it is clearly stated that if a demand is made under Section 74, then there should be a material evidence on that taxpayer stating that why this demand has been made with an allegation of fraud or willful misstatement or suppression of fact to evade tax. So, on this ground, the taxpayer took plea before the High Court. There is no evidences or based on which the Section 74 is imposed. Therefore, this demand is faulty. Allahabad High Court accepted all this plea and said that there is no verification of evidences submitted by the taxpayer and simply demanding under Section 74 is wrong. Stating this, the High Court remanded back this matter for reconsideration based on the evidences submitted by the taxpayer. A very useful judgment of High Court. I hope you found the video useful. Thank you so much.